Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala Rasulillahi sallallahu alayhi wasallam. Assalamu alaikum wa rahmatullahi wa barakatuh. Jazakallah khair, everyone. Welcome to today's webinar, the uh, the monthly Sharia webinar series. This is the fourth series of our monthly series, brought to you by Bank Rakyat, INCEIF University, the International Islamic University of Malaysia, and Darasat for Research and Consulting in Islamic Banking. As usual, my name is Izzuddin, and it is my pleasure to be your MC for our webinar series. And today, we have an exciting topic for the webinar today, entitled The Impact of AI on Regulatory Frameworks in Islamic Finance, Balancing Innovation with Sharia Compliance. And our speaker today is Dr. Najib Zada. Now, a bit about Dr. Najib. He is a research fellow here at INCEIF University under the Center of Excellence for Applied Sharia in Economics and Finance. And Dr. Najib is an experienced academic and legal professional with a PhD in Islamic finance from INCEIF itself, alhamdulillah. And he has an extensive teaching and research experience in Islamic studies and law. He has been a faculty member at Islamia College University in Peshawar since 2010, and where he teaches and supervises students at the bachelor, master, and PhD levels in subjects such as Islamic law, fiqh, and tafsir. Dr. Najib has also a strong background in legal consultancy, having served as the senior advisor at Mohammedan Law Associates and senior consultant at Islamic Finance Advisory and Assurance. And he has also conducted various seminars and training in Islamic finance and law, while also contributing to legal research and legislative projects. So without any further ado, I would like to pass the floor on to Dr. Najib. Oh, sorry. Before that, ladies and gentlemen, as usual, if you have, Dr. Najib will be presenting for about half an hour or so, and we will then open the floor for Q&A. For any questions, our dear attendees, please do submit them in the Q&A window below, and then we will have, if time permits, I will try my best to address all the questions, inshallah, apart from our other panelists joining us today. So without any further ado, Dr. Najib, the floor is now yours. Thank you. Unmute, sir. Dr. Najib, you're muted.
Can you listen to me now?
Yes.
Okay.
Perfect.
بسم الله الرحمن الرحيم نحمده ونصلي ونسلم على رسوله الكريم سبحانك لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. Thank you very much, Brother Izzuddin, for the introduction, and thank you everyone who is participating in this webinar today. And thanks to all the organizers, keeping in view the fact that it is 1 to 2 p.m. time here in Malaysia, which is usually the break time. So without going into formalities, I will just directly come to the topic, which you can, I hope, see on the screen. It is about the impact of AI on regulatory frameworks in Islamic finance, balancing innovation with Sharia compliance. Before entering into this topic, as we all know that this series has been there for quite a few years. In the past few sessions and webinars, we have had a lot of discussion. Very learned and seasoned scholars were there, and they have basically explored various aspects of AI in Islamic finance from various angles and perspectives, and there were very fruitful points brought to the attention of the audience and the participants in those seminars. Coming to this webinar today, if we look at the table of contents, so of course this is, I would say, the traditional table of contents, but due to the time limitations and based on the facts that there has been quite significant discussion in this webinar previously on many of these aspects, so I would try to do that I would skip some of the parts in this table of contents, which I would say are the participants would be quite familiar. I expect that. And instead of going through those parts, I would actually try to take this gathering, the participants today, into something that is really applied and that is really related to those people, the Sharia fraternity, which we may call, or anyone who is working or who is associated with any organ of that Sharia governance framework, whether that is Sharia audit or that is Sharia review or Sharia secretariat or Sharia committee or any individual Sharia scholars working in any individual capacity. So we would try to go into a practical example in a case study, and the purpose of this case study is to not to basically focus on something that is related to one aspect, a particular aspect of Sharia compliance. Rather, it is related to the role and the responsibility, very important, the responsibility of the Sharia fraternity, because that is something on which there has been very least discussion and which is quite understandable actually. Because the legal, regulatory, and ethical framework for AI in Islamic finance is not developed at all. We rarely see some discussions. We rarely have some cases. However, on the other hand, if we look at the conventional sphere, I mean, let's say in the legal arena, so we have a jurisprudence developing in the process of development across the globe, and I believe although those cases are not related directly to Islamic finance, but the questions and issues and challenges which are raised there, whether they are related to ethics, they are related to law, where they are related to the regulations of AI. So I believe they are quite relevant to Islamic finance. And for this reason, instead of going into all the preliminary discussion, the challenges, the pros and cons of AI, which as I said, that most of us know already, I would try to take the forum to directly to the case study related to ethics, law, and regulation in AI. A quite interesting case, and in fact, there are quite a few lessons embedded over there, from which the Islamic finance community in general and the Sharia fraternity in particular can learn so many things. In fact, we do have a number of questions arising from that case study, which we will deliberate. Of course, it's not a face-to-face discussion, so we cannot discuss it in the form of a group, but the main purpose of this webinar, I would say today, is thought provocation and thinking and having a look at the other side of the coin, other side of the picture. Because we know about the bright side of AI, very much understood, and everybody is affected by that, and everybody is benefiting from that. But the question is that what does the Sharia fraternity need to be aware of when it comes to the challenges, when it comes to the, as I said, the other side of the picture, the other side of AI. So this case study is related to that, and I hope you will find it interesting. And this will basically, hopefully, make you think about the use of AI, particularly if we are related or affiliated to the aspect of the Sharia compliance aspect of Islamic finance, as I said. So if I just have a look at okay, we just skip it. I believe these are the slides a bit. Okay. Okay, now this is basically the factual background of the case. So a case is submitted in the US District Court, which is duly signed by 3 attorneys. I'm very sorry I have the slides of the old version, but anyway, I hope it will be easy for you to understand them. I can share the updated slides later on. Because of some issue in the system, I wasn't able to copy them here. I did copy, but it's the older version. So in the US District Court, which is signed by 3 attorneys, who are Mr. A, Mr. B, and Mr. C. Interestingly, the court finds that out of the 9 cases cited in the submission, 8 were basically generated by ChatGPT without having any existence. So in other words, they were basically fake. And we must keep in mind that this submission was basically unintentional. It was unintentional. It was not done basically intentionally. Accordingly, the court did what that it served a show cause notice upon the attorneys and asked them to explain their position why disciplinary action should not be taken against them. The attorney submitted an apology to the court and accepted their mistake, but the court still decided to proceed against them. So in the detailed judgment, the court elaborated upon some important aspects of using AI in the complex legal, ethical, and other questions arising therefrom that will be discussed next. Now, just we in order to apply this case to ourselves, let's just try to do try to hypothesize something. So if we were to replace the attorney in the above case with Sharia scholars, so instead of attorneys, we say there are 3 Sharia scholars who basically drafted anything. It may be a Sharia resolution, it may be a Sharia audit report, it may be a Sharia report. It may be basically a research paper, because we will see time and again that this case is not only related to legal fraternity, its applicability is quite vast, and that's why the court frequently refers to the research fraternity too. What would be the implications and the possible ethical, legal, and regulatory questions that arise in this case? Similarly, what would be the possible answers to those questions? But we should keep in mind, as I said, that we are using the word Sharia scholar not to basically have a particular segment of the Sharia governance framework into this, but it's just for the sake of convenience and easy reference and discussion. It's only for that purpose. And as I said, that this is something which has universal applicability. Anyone who is using AI, relying on AI in the performance of their job, they can basically put their names or their position here instead of the attorneys. So now from here onwards, the court is basically touching upon various aspects of using AI. So the first thing that the court talks about is about the ethics of using AI, as we can see that according to the court, while technology continues to evolve, one thing remains the same. It is, I cannot see okay. It is checking and verifying the source. Checking and verifying the source. Very important, very important. So no matter where the technology reaches, it is upon the user to basically check and verify the source, cross-check and having a check through other sources. I mean, they can be physical sources, other online sources, but ever reliance on these AI platforms can be quite troublesome at some point. The court also says that as attorneys transition to the world of AI, the duty to check their sources and make a reasonable inquiry into existing law remains unchanged. Very clear. The instant case is simply the latest reminder to not blindly rely on AI platform citation. Very important, and I would say very important lesson for all of us in the area of Islamic finance, although this is something that is related to the ethics of Islam in general, and every Muslim, I mean, looking at the injunctions or the sayings of the Prophet ﷺ, or even in the Quran, we need to basically authenticate these things ourselves before reporting them or making them forwarding them to anyone else. But anyway, just blind reliance on AI platforms, it can be dangerous, as we said. And the court also next said that Boolean search through a database, this is not going to be sufficient, and is something that will still make one accountable. And lastly, the court said the researcher must still read the case to ensure the excerpt is existing law that supports their proposition and arguments. So this is what the court thinks about the ethics of using AI. Now, the question of what issues are there in AI? As we know from the literature, and we have other slides that you can see later, there are a number of issues when it comes to the issues, the problems, the challenges that are existent there in AI. But the court in this particular case, looking at the background that there were 8 fake cases generated by ChatGPT, so it refers to AI hallucinations. According to the court, the current state of AI has its shortcomings. The legal profession has been cautious to make a head-first dive, partly because of the concept referred to as AI hallucinations. This occurs when an AI database generates fake sources of information. Just in this case, 8 fake cases. It is also well known in the legal community that AI resources generate fake cases. This is something important for us. Why? Because although we do not have any cases in Islamic finance, at least coming to the surface, when we see that in terms of Sharia compliance, in matters related to Sharia, in Islamic finance in particular, there is a case in which any AI platform or system has basically been the subject of hallucination. But this is a reality. This is a reality which is known to the legal community. So I believe that the Sharia fraternity should also be aware of it. So biases there in AI, these are the other issues that the court has rightly pointed towards. Now, this is something that is the consequences when someone is faced with or someone is the subject of AI hallucination, and without doing a proper inquiry, proper check, if they commit something, if they draft something, if they submit something. So then the question would be that of accountability and liability in the group work, particularly in the group work. This is something I believe is really important for the Sharia fraternity. Now, in this case, there were three lawyers, Mr. A, Mr. B, and Miss C. And if you look at the role that each played in this particular case, so Mr. A drafted the case at the direction of his supervisor, Mr. B. So the drafter basically is Mr. A only. Mr. A took help from AI to generate relevant citations of the past cases of precedents supporting the case, just as any other lawyer would do. Mr. B, the boss, had suggested excluding a term that was used in the draft, but he otherwise had no involvement. It's quite interesting because in group work, usually, we are researchers and we usually work in the group. So the question is that if it's a group work, so generally speaking, which member of the group is responsible for how much of the task, the distribution of the task? It can be like 10 and 90%, it can be 5 or 95%, whatever the arrangement is, depending on the nature of the project one is undertaking. But the thing is that in this particular case, we see just a single term was changed by Mr. B. As long as Miss C is concerned, so she was not involved in drafting the case at all. So in fact, her contribution was zero, it can be said. But irrespective of the contributions made by each, all three attorneys affix their e-signatures at the motion, which is a legal requirement, and usually when the work is undertaken in the form of a group, so all the group members, they would claim entitlement to that final product, which is the norm in almost, I would say, every profession in which the work is performed in the group form. One step ahead. Now, this affixing signature, what does it mean? What does it mean? Because when we talk about liability and accountability, so legally speaking, affixing one signature has its significance. So according to the code, signing a legal document ensures that the attorney read the document and conducted a reasonable inquiry into the existing laws. By the way, these slides, I basically took the words as it is from the judgment, which is available, and I can share it with you later if you want to read it. There are only a few places where I have modified the words, otherwise these are exactly the words. The authority must stop, look, and listen before signing a document subject to Rule 11B of the Federal Rules of Civil Procedure that you can find there. That once a document is basically presented to the court, so an attorney or representative party certifies that according to their knowledge or their belief, they are correct and they have read it, and the content is such that the legal responsibility has been fulfilled. So this duty is non-delegable responsibility, very important. The responsibility of an attorney to basically stop, look, and listen means check carefully. This is something that cannot be delegated to another person. We can say that لا يجوز التوكيل في هذا الباب. This is something for which the person who signs the document himself or herself is responsible, and no one else can be dedicated this authority. Thus, the court ruled blind reliance. These are actually the words. These are actually the words of the court, the judge. Blind reliance on another attorney can be an improper delegation of this duty and a violation of Rule 11. An attorney who signs the pleading cannot simply delegate to forwarding co-counsel his duty of reasonable inquiry. The same thing, tawkeel in this chapter is not allowed according to the US laws. Of course, we are talking about that, but now this is something working in a group. It's something everybody understands because usually we do work in a group form. And lastly, reliance on others was indeed an improper delegation of his responsibility under Rule 11 to certify that the filing filed over his name was well grounded in fact and in law. So an attorney needs to check that both the factual background of the case as well as the legal precedents and the legal backing of the case, they are accurate to, of course, according to his knowledge. So this is what the court next proceeds to about the content. It's not that a member of the group just reads the draft and tomorrow, let's say if there is an issue, he can basically even swear or take an oath that I did read the draft. No, even the content has to be read to such an extent that he's satisfied that the same can be submitted in the court of law. Nevertheless, no inquiry cannot be deemed objectively reasonable even if the reliance is placed in an inexperienced attorney. Reliance is placed in an experienced attorney. As a matter of fact, this notion of trustworthiness and reliance on others, which is, I would say, being Muslims, is very much well known to us. And among the Sharia fraternity, this is something, because we usually work in the form of a group. So this is something quite understandable to us. And whether it's the Islamic finance industry, it is the Islamic finance research centers, everywhere this is quite well known and commonly known. One who signs a motion or filing and fails to reasonably inspect the law cited therein violates this rule. Once again, the same idea. Every attorney learn in their first year contracts class that the failure to read a contract does not escape a sign-off of their contractual obligation. Once the sign is there, the existing of sign is actually equal to the liability of the person who thumbs a sign on the document. He or she cannot claim later on that I didn't have time, the other person was very experienced, he was very skilled, I had trust in him. All these things in the legal parlance will not be sufficient to basically shift the liability from the sign-off. This is also the same continuation of the same reliance on someone else's reputation or experience. The court notes that Mr. B and Ms. C did not review the motion prior to signing, because they arrived at this conclusion and the attorneys, both of them, confessed this too. However, Mr. B and Ms. C do not contend that Mr. A signed their name. Yes, the permission was there. The permission was there, because if the permission was not there, then Mr. A would be liable to some serious consequences. But in this case, both B and C, they accepted that, yes, it was with our permission. It appears, court notes, that it appears that Mr. B and Ms. C relied on Mr. A's reputation and experience, something very much pertinent to Islamic finance, to comply with their Rule 11 obligation, which is their obligation to read the document, to understand it, and according to this, their satisfaction, ensure that it is now ready for submission in the court of law. So reputation, experience, and trust. This is something frequently talked about in Islamic finance among the Sharia fraternity, and the basis of which so many things are actually done in the industry. This is perhaps the most important aspect of this case: ethics in legal profession and the public perception. Because when we talk about Islamic finance, so we say that the people, the masses, they have trust in the Sharia scholars, and it is because of this trust that the industry is thriving. The Muslims, they're quite satisfied with it, and they put their money into Islamic financial institutions. So these figures, these big shuyukh, they are really the backbone of the industry, as we know, and we frequently come across this term. But in terms of penalty, the court first turned towards Mr. A, the liability in the case. Mr. A was only a pro hac wise. It's actually a kind of limited license given to the attorneys in some districts, some states of the US. This is a privilege, and it may be revoked for unethical behavior. To determine whether the status should be revoked, the court looks at three aspects. Now, this is why we have this slide over here. Society's interest in ethical conduct. Whether the masses have trust in a particular individual or institution or a group, this is what the court will actually look into. And on the next page, as we can see, for the first, the society's trust in that particular group. Society's interest in avoiding the unethical behavior of citing fictitious cases is significant. Yes, they are interested in it, and their stake is involved. because they trust Sharia fraternity, they have a big stake in it. They have a big stake. The quote here refers to another case, earlier case, Mata, very famous case, that one. Many harms flow from the submission of fake opinions in the court of law. If you just focus on the highlighted words there, so it promotes cynicism now. Submission of fake documents which are not verified. It promotes cynicism about the legal profession and the American judicial system. I believe we can very easily relate to this, that if these incidents start happening, I mean, at least in my knowledge, we don't have any incident happening, but the thing is that it certainly is going to tarnish the image of the industry. And now that image is something which is extremely important for Islamic finance, particularly for Islamic finance. In short, the judge notes society has an interest in the attorney's ethical conduct, and Mr. A's conduct fell short of that standard. The way he did, I mean, he generated the cases through ChatGPT basically, and he didn't bother to check their validity and authenticity. Now we just skip these sanctions because there are a few important things coming later on. Yeah, but there's something interesting. Mr. A who was the drafter, basically, he was sanctioned and fined USD 3,000. Now, this may be kept in mind because when we compare it with Mr. B, who basically changed a single word, that's quite interesting, So he was sanctioned less severely, just $1,000, And the last two lines, as you can see, his reliance on Mr. A's experience was understandable, but he still has a non-deligible duty to ensure a motion is supported by existing law. So he was not supposed basically to make him his wakil and just ask him to check and verify everything, and I'll just have my signature there. No, he was not supposed to do this. But his liability, because he didn't draft, so according to the court, according to the judge, his responsibility is less. And similar is the case with Missy. She's fined for $1,000. And she also had a non-eligible duty to ensure that a motion or filing is supported by existing law, and therefore she failed to perform this duty. This is basically the crux of the case, and as I said, I will share the detailed judgment that any one of you can read. It's quite interesting. In fact, there are a lot of other aspects which have been touched upon by the court, but this was something that was related when we talk about ethics, when we talk about law, when we talk about regulation, vis-a-vis artificial intelligence in Islamic finance. So I think this the factual background of this case tells us a lot of things about what we are doing, how things are done in the industry, and how there can be situations which will basically result in some unwanted scenarios for some members of the Sharia fraternity, and that's why we need to be very much cautious while relying on AI and whatever is produced by AI. As human beings, this oversight and checking and verifying the authenticity of whatever is generated by AI, that is something which even under the US, I would say that their ethical paradigm is something which cannot be evaded by anyone. So when we compare it with the ethical paradigm of Islam, so I believe there can hardly be any two views that this is something towards which we won't hardly have any controversy, and to which we must be ethically very much. Even if we ignore the legal consequences and the regulatory punishment or procedures or something like that, so ethically, the Sharia fraternity should be very much on guard and very much cautious about it. Now, looking at this background and looking at the time at the same time, so many questions pops up to the mind. And as I said initially, the purpose of this session is basically to induce thinking about this issue, which sooner or later we are going to see. It's just a matter of time. It's just a matter of time that we will have these kind of problems, because we know that the acceptance of AI among the Islamic finance community It's a very high level, and in fact, people have been using it and benefiting from AI in so many diverse ways. And definitely, it has improved the performance of the Sharia fraternity. And so many studies have shown that the acceptance of AI among the Sharia scholars, among the different organs of the Sharia governance umbrella, it is very positive, it is very high, and this is something that should be appreciated. But as I said initially, that we need to be aware of the other side of the picture as well. So the narration of these few facts related to this case actually it automatically leads to some question. We have drafted some of the questions, and of course the list is not exhaustive. It's just for the sake of discussion and thought-provoking, as I said time and again. So we can add so many other questions. I really appreciate that if the participants can actually add to this list of questions. Because then when we basically have the chance to discuss these questions under one roof, so I think this list of questions will be quite beneficial for that purpose. There are just a few questions. Question number one. Now, some of these questions are directly emanating from this discussion so far or from this case. Some of them are very hypothetical, but as I said, they're not that much hypothetical. It's just a matter of time. So if you find some questions that they are not related to this court case, which we just summarized and looked into, so please don't be worried about that. Question number one, is issuance of a fatwa generated with the help of AI valid? Of course, there can be so many scenarios. We need to look at the content of a fatwa or resolution, whether that is correct or not. We need to look at the sources and the human involvement. So many things are there, factors are there on which the answer to this question will depend. Question number two is that what would be the liability of the scholar signing the fatwa, for example, when later the same is found to have unauthentic material or sources? So basically, there are three scenarios. We find that the content of the fatwa resolution itself is questionable, but not the sources. Vice versa, the sources are questionable or fake, but not the ruling or Sharia resolution or fatwa. And the third case when both of them are questionable. So I believe when we are discussing this question, so we need to keep all these three scenarios in mind. Question number three, if an AI-generated resolution is found to be incorrect later and unintentionally, because as I said initially, we are talking about the unintentional generation of these inaccuracies. Which of the scholars would be responsible and to what extent? This case actually, it's quite interesting that the person who drafted the case was subject to the most severe punishment, but those who didn't, I would say, participate at all, they were subject to least punishment. So will it be Mr. A, Mr. B, or Miss C? I mean, three people are there in the book and they have signed some document. One contributed, say, 99%, one contributed 1%, and the third one 0%. So the proportion of liability, what would that be? Question number 4, what are the non-deligible duties of Sharia scholars? Very important. Question number 5, is public trust in Sharia scholars a sufficient legal ground for holding them responsible in the case of mishap while using AI? Just as we saw here, the public trust in the legal fraternity within the United States, that was taken as a ground because of the reputation of the industry. So of course, when we talk about the reputation of the Islamic finance industry, it is way more than what we have in the US among the legal fraternity. So this actually raises this question that, okay, there is no explicit law, there are no regulations in place from the regulator side, but if something like this happens and that too unintentionally, then the question would be that this reputation among the masses about the reputation of the Sharia scholars, I mean, will it be a sufficient legal ground to subject them to some kind of proceedings? Question number 6 is that whether the question of fair compensation arises in the case of using ITO. This is something related to some other cases, but of course, if we say that 2-3 years back, if a resolution was issued, just as an example, we are taking it as an example, a resolution could be issued in, say, 10 hours, but now with the help of AI, the same resolution could be issued, let's say, within 30 minutes. So, is it a question, as it's been asked in the legal side, Is it possible that we ask that the compensation should not be that much as it used to be 3 or 4 years back? Question number 7, in the absence of a separate code of conduct concerning AI, who will perform the check and balance in the IF industry? Is it like self-regulation? The Sharia fraternity will basically have an eye on their conduct themselves, or the regulator, they are required to come up with some kind of piece of regulation, or it's the court of law that ultimately if things go wrong, so the court will decide. This is also an important question. Next, can AI replace the human functions in terms of Sharia compliance? This is also very much important. And number 9 is, will the use of AI increase the opportunities of arbitrage in Sharia compliance? We already have this notion of fatwa shopping. So the question is that, and it's just an example that we discussed a few days back, that if there is an app which is AI app, which originated from Malaysia, let's say, and then there's another app which originated, let's say, in the GCC. So of course there can be some differences in the outcome that both these produce. So will we have that fatwa shopping kind of result in this case as well? Next question, whether a specific code of AI ethics is needed for Sharia fraternity. Because as we said, that is it an individual responsibility? Is it something that the regulator should and can interfere? Next, when developing certain AI platforms within Islamic finance be biased? We just gave an example. And I think we do have an example of how, even nowadays people ask about it, how the word interest is used in the system instead of the word profit. So that is what actually AI bias is, because it has been fed with the data, and the bulk of that data actually carries the word interest, and it does not have that profit. So yes, this bias can also be there. Will AI-based systems be efficient enough to go beyond the formalistic approach and look deeper into the essence of Sharia, which, like Maqasid al-Sharia, maybe a product is perfectly fine from the legalistic perspective, but there are some issues with respect to, from the perspective of Sharia, Maqasid al-Sharia. So the question is that, can AI go to that level too? How and where to draw the distinction line between the permissible use of AI and negligence? So this case actually provides us the scenario that AI can and should be used. In fact, the judge is very much positive initially in a few paragraphs, and he says it's something that we should be utilizing and taking advantage of, but then he comes to these other questions. So the point is that, what is the extent of utilization of AI? Where should we stop using it? And from that point onwards, we should basically proceed with using our own intellect and energies and time. The second question, can AI replace the human functions in Sharia compliance? Because Sharia is so much complex, there are so many factors beyond just looking at the documents, looking at the terms and conditions of the contract, that it makes it quite a complex system. So is it possible that AI will replace the role of the Sharia scholars in the future? There are, of course, two opinions on this, as most of us know. And the last question is that, will the use of AI increase the opportunities of arbitrage in Sharia compliance? We have just referred to it earlier. There may be cases where one jurisdiction or one AI platform is more favorable to an individual, to an Islamic financial institution, or to a company or entity, as compared to another AI platform. So is it the same thing, more or less, like the fatwa shopping? Which one will the company or the individual go for? So there is every chance that the Sharia arbitrage opportunity will be created there. So I will just stop the discussion here, because I think it's already 1:45. And on a lighter note, if you have any answers to these questions, so I will highly appreciate if you can share those. It's just on a lighter note. I really wish the discussion was like face-to-face, so that we can discuss some of these questions. And of course, there are some questions can be answered very definitively, but others need deliberation and discussion. But anyway, these are the my thoughts on this topic, and I will share the judgment with you later, as well as the slides that you can use. And hopefully in the future we can have some more discussions like this. Jazakumullah khair. Thank you very much for your patience. And back to Brother Izzuddin.
Jazakallah khair. Thank you very much, Dr. Najib, for the very thorough and interesting presentation on the impact of AI on ethics, law, and regulation. So normally I would open the floor for Q&A, and normally our panelists or our attendees would ask the question, but now you have reversed the process. You have already posed the questions and for our attendees to answer. So I will welcome any more questions or the answers to those questions that was posed by Dr. Najib from our viewers. If you have any questions, do submit them in the Q&A window below, and then I will try to post them as best I can within the allotted time, inshallah. And also, I would like to open the floor to our panelists. If they have any questions, please do just go ahead and unmute yourself and ask away. We have Prof. Dr. Azman with us, Dr. Atazaiti, and also Ustazah Nuliza with us. If you have any questions, please do ask them. Perhaps for me as a layperson, the most common question that we have when it comes to discussing about AI and the impact of AI in the respective industries is, I mean, you already had that on number 14. Can AI or will AI replace the human functions in Sharia compliance? For us, for me, on a daily basis now, we use AI to improve our job, to make it faster, certain elements of our job to be faster. But here, from your point of view, Dr. Najib, can AI replace certain human functions in Sharia compliance, or either a part of it or a total replacement? What would you think?
Brother Azim, this is, I think, a very important question, and that's why we put it there in the slide. So I believe it can help the Sharia compliance function, help the Sharia fraternity in performing their function. But as far as 100% replacement is concerned, so I believe that would be something, I won't say impossible, but that would be a bit tricky and, allow me to say, a bit dangerous for the industry. That's my personal opinion on this.
Right.
In fact, I have a slide. I will see if I can just find it.
Sure.
So I'll share the slide with you as well. In the European Union, even actually, they say the legislation that they have, they actually said that human oversight, by the way, European Union in 2024 became the first region in the world which came with an act of parliament to regulate AI, that is AI Act 2024. And actually, they have even referred to this human oversight so many times, and also this ethical aspect of AI so many times in that act of parliament, which I think should be an eye-opener for all of us. Okay, so if you allow me to share my screen with you, I believe this is yeah, this is what it is. And yes, I will just share this one slide. So this is the AI Act 2024. As I skipped this slide due to the time limitation, because I just wanted to come to the crux of the matter, so we can see that human-centric, just the bold words, human-centric approach to AI. This is the European Union's approach, human-centric. Trustworthy and ethical AI. Importantly, before this act, there was actually those ethical guidelines for AI and trustworthy AI. The documents even which were issued by the European Union, so they didn't say AI simply, they say trustworthy AI, trustworthy AI. That's very interesting. I mean, they are very much and pretty much advanced in AI and technology and almost everything that we know of. But the thing is that they are so much concerned that when coming up with these kind of documents, they basically add this prefix of ethical AI, trustworthy AI, which was quite, I mean, interesting for me when I was just reading these documents. So trustworthy and ethical AI. So yes, if we have time, next time we can see that how the West is approaching this issue, and they say that 100% reliance on AI, it would be tricky and dangerous. That's why they want this human involvement to be there.
But where do they draw the line on what is trustworthy and what is not? Which AI model or?
So if we look at this AI, the AI Act of the European Union, which has been introduced recently, so they actually draw so many points. I mean, if you look at their overall approach, so this is their approach, risk-based approach. So they draw the distinction that okay, the use of AI in this area is unacceptable. So they basically would give a list. For example, I mean, just as an example, we develop a software which is able to crack and to detect the password of the users. So there's something they say no, simply no. Then there is other area, high risk. So finance, for example, they say high risk. So they have very strict restrictions for these industries which fall under the high risk AI systems. And they say, okay, these are the procedures which must be followed, and these things cannot be done, and these things must be done. And then the third one, that is the limited or minimum risk AI systems. So, for example, video games are there, or just like inventory management are there, stuff like that. So for them, the requirements are quite lenient, I would say. So there are quite a few things in this act that we can learn from, but as I said, due to the time limitation, we had to skip those things. So my opinion on your question is that removing human beings from this, particularly from the Sharia compliance perspective, it would be a bit dangerous.
All right, thank you. If there's any questions from our panelists or our attendees, do send them in. I think this is another question that is typically asked for our speakers. Can we have a copy of the presentation slides?
Yes, inshallah, I will provide the updated one. This one is not updated, by the way, because of this issue that we had in the system. Surely, I will provide that.
Excellent. We will once we get the updated one, we will send by
yes,
email.
And in fact, I will also provide the copy of the judgment if anybody is interested in that.
Excellent. And then I guess if I can ask, looking at this another question just popped into my mind. Do you see this, or has it already been adapted into Malaysia or within this region, this risk-based approach of the AI Act?
I think this, in terms of in the context of European Union, it is because if you look at the timeline, so the Act has certain segments. It's quite a bulky one, actually. It's like nearly 140, 150 pages. And the implementation duration, because of now, this is the tricky area. They did not implement it from 2024 to the time span for implementation is until 2030.
Right.
So you can imagine that this is such a tricky area that a region like European Union takes 6 years basically to implement the act which they have passed. So I mean, these are the challenging issue in this area. So Malaysia may have implemented some part of it, but I think not the whole of it. Not the whole of it.
Okay, excellent. Yeah, if there's any other questions, please do send them in. As one of my lecturers were saying, when there's no questions, this usually means they understood everything or they understood nothing. So hopefully it's the first one.
It may be that I asked the question and they're thinking about the answer.
Yeah, maybe, because you already had all the questions already listed, what, 15 or so questions. So perhaps they're thinking about the answers for that. I guess if there's no other questions, maybe I'll leave the final few minutes for any final notes or the outlook of our topic for today. Oh, sorry, not outlook, but the outlook of the AI and its impact on the industry today. Yes, Prof. Azman.
Okay, Bismillahirrahmanirrahim. It has been a very impressive presentation from Dr. Najib. It's totally new area to me, and I think it's to many of us AI. And what I can recall just now, you mentioned something about the delegation, of the Sharia committee might delegate, for example, the Sharia department or Sharia management or Sharia advisory, for example, to give approval. Sometimes in the industry, they need a prompt and quick response and the Sharia committee might have a monthly meeting, or sometimes after 2 months they might have their meeting. But delegation is very crucial. The Sharia management, for example, once they get the mandate from the Sharia committee to give, certain approval, like for example, for the advertisement materials, and also for to underwrite a certain business, when it comes to the kafur, to underwrite, the risk, or when it comes to banking, to give approval to the financing application, and we have to do the assessment. But I just wondering, by having this AI, how can we can how we going to synchronize, because the responsibility, definitely rests with the Sharia committee members. How to synchronize. There might be circumstances where we come across irregularities, and later on is the audit team or the Sharia review team, we come across, or these findings. Yeah, in general, because we're talking about AI, how to manipulate, how to make use of AI to make sure that we can synchronize the whole process, to make sure that we comply to the Sharia requirement from A to Z. Jazakallah khair.
Thank you very much, Prof, for your comment. I think there was no question, and I appreciate your comment. And that's why we put the question, which part of Sharia compliance could be delegated? That's why we put that question, because as you said, the delegation takes place in the industry. And there was another relevant question that we posed, that can we have an ethical guideline? Probably these things are covered under the ethical guideline, if not a regulatory one. So yeah, this is why we have these gray areas. And I believe this topic is very important for the Sharia fraternity.
All right, thank you very much, Prof. Azman and Dr. Najib. I guess maybe one final note from Dr. Najib before we close the session.
Just from my side, brother, thanks to all the participants and for Prof on the feedback or the point that he raised. And I believe this is an issue on which the Sharia fraternity should start thinking, because as I said twice, I think that this is just food for thought. These are the questions which will be faced by the community. It's just a matter of time. So better start looking for the solutions, start debates, and start having some ethical or regulatory guidelines, or anything that can basically save the industry from some unwanted situation. That is basically the purpose of this presentation.
Jazakallah here, Dr. Najib, for that engaging and thorough presentation on our topic today. Alhamdulillah, ladies and gentlemen, we have concluded our session today. Thank you so much for joining. Sorry, apologies. I'm facing some technical issues. Right. Thank you very much, ladies and gentlemen, for joining. Once again, we appreciate your contribution, your engagement throughout the session. This has been the fourth session of the monthly Sharia webinar series, and do tune in for our fifth session on next month, on the 22nd of May, for the next iteration of the monthly Sharia webinar series, brought to you by Bank Rakyat, INCEIF University, in the International Islamic University of Malaysia, and Darasat for Research and Consulting in Islamic Banking. My name is Azuddin. It's been my pleasure to be your MC as always. I end my duty with Wabillahi Tawfiq wal Hidayah. Wassalamu alaikum wa rahmatullahi wa barakatuh. See you in the next event, inshallah.